First of all, I would like to state that my decision is based on the following. The argument presented by the defendant, Ms. Kawana Anderson, the argument that I assume would have been presented by the plaintiff, Casey Stevens. I say assume because I have not been able to access the video link in which the plaintiff's case was presented. However, I have considered what the plaintiff's argument might be given the facts of the case. In the next few days, I should gather more evidence on this. I will provide further comments as I respond to my classmates. A review of the legal and ethical standards surrounding the issue of privacy and confidentiality. Here is my opinion. An individual has the basic legal right to privacy, and this is part of the constitutional amendment. In a patient to doctor relationship, an individual still retains this right, which is based on mutual care and respect, and so the patient expects that any intimate details related to his or her records will be kept private and not disclosed to any third parties without their consent. The Privacy Act of 1974 is used to protect both the patient and the provider in such cases. For the patient, it is expected that details to the patient's illness and treatments will be kept private for use only in the use only by medical staff and medical people related to the case. For the healthcare provider, HIPAA ensures that the healthcare provider's obligation on keeping this information confidential are carried out in a legal and ethical manner, and that any details disclosed are with the consent of the patients. This is furthermore supported by the Privacy Act of 1974, which indicates that the only exemption from these conditions is when details are needed for law enforcement or investigation purposes. The Health Insurance Probability and Accountability Act, HIPAA, is used to provide guidelines and the privacy and confidentiality of medical records. This act indicates that there are 18 patient identifiers such as names, contact details, images, and other such information that is used to identify patients. These identifiers must be present if medical records of patients are to be seen by third parties. Furthermore, HIPAA also allows disclosure of patient information by healthcare providers in order to facilitate treatment. However, in such cases, it is expected that the healthcare provider would take reasonable steps to ensure that only the minimum information is disclosed as necessary. To reinforce this, HIPAA says that workers who have access to medical records must protect the individual's privacy and must be educated about privacy rules and procedures. Peterson, 2012, goes on to remind healthcare providers that although a medical record is maintained in order to foster quality and continuity of care, this is a legal record and care must be taken when information contained is kept private and also is kept private and confidential as required. In the case of Albright Smiles Dental, flagging of files with the red sticker to identify AIDS patients may have been done in order to ensure that extra care was taken during the treatment process and that additional measures were taken to protect these patients and others. However, it is not clear why the words AIDS were clearly written for all staff and other patients to see on the medical records. The argument presented by the defendant are, in my opinion, not valid because of the following. The consent forms. The defendant has indicated that the consent forms were signed by all patients. While this was a standard medical practice, the signing consent forms that include privacy and confidentiality still does not discharge a provider of the right to not protect information that is considered to be private to the patient and does not need to be shared with those who do not need to know. Bastillos 2013 reminds us that consent given by patient is guided by the American Medical Association of 2001 ethical principles. These principles state that a medical provider should not reveal confidential information without the consent of the patient. In this case, the patient gave consent for the information provided to be used for treatment and not for disclosure to third parties. Although the defendant says that the medical records did not have any identifiers, this would be unlikely because a medical record needs to have a name and other identifiers in order to specifically identify patients. Without these identifiers, the medical records would be at risk of mixing up patients' records, and so it is unlikely that these identifiers were not present on the files. Given the facts of the case, I would rule in favor of the plaintiff because due care was not taken to protect the confidentiality of the AIDS patient. The medical records could have been flagged with a sticker of some sort. However, there was no need to have the words AIDS clearly shown on the outside of the cover, which is visible to other patients and staff. This was in clear violation of HIPAA. Sauka and Lai 2000 in the article on confidentiality and disclosure of HIV-related patients stresses the need for healthcare practitioners to maintain the secrecy of HIV-infected patients if they are to form a relationship of trust with the patient. In the article, a survey was conducted in which patients emphasized that medical providers' procedures often do not take into account the need to maintain this confidentiality due to the stigma associated with the disease AIDS. Thank you.